This particular session that we're beginning provides you, or will hopefully provide you, with a clearer understanding of the leading land use rulings that promulgated by the Virginia Supreme Court since the year 2000. When we started our dialogue as a panel, I threw out the notion of the top 10 cases, and then it went to 12, and it went to 15, and I think we're up to 20 cases. And it's hard to trim that down to a smaller, more manageable number. The handout that you have features the case, an overview of the case, assessment, and then comment relative to the takeaway, if you will. Our panel that worked to bring this about with us this morning features Greg Cantler to my immediate left. Greg is Deputy County Attorney here in Albemarle County. Many of you know Greg as an individual because he is one of our instructors in our Virginia Certified Boards of Zoning Appeals training program. He's also been very active with the Virginia Association of Zoning Officials with their certification training, and he has lectured in various venues with 60 or more local governments across the Commonwealth. And Greg witnessed exemplary work in pulling the handout together for the panel, his panel colleagues, and for your benefit as well as mine. Next to Greg is Sharon Pandak. Again, many of you know Sharon. She's a partner with the law firm of Brehan, Taves, Pandak, and Stoner. She works out of the Woodbridge office. 15 years as county attorney in Prince William County. Has been a partner with her firm now. I guess, golly, going on 10 years, I guess, just about 10 years. She's also general counsel as we speak for the Metropolitan Washington Council of Governments. She's argued cases locally, also at the Virginia Supreme Court and the United States Supreme Court. And Sharon, of course, is one of our instructors in both the Certified Planning Commissioner program and the Certified BCA program, and a regular presenter in other programs that I've been party to, the last 25 years, when she was only 10. Next to Sharon, to her left, is Andrew McRoberts. Many of you know Andrew. Andrew is legal counsel with the local government practice group at Sands Anderson. And Andrew, has it been 5 years, 6 years? How many years now?
5 years this month.
Oh my gosh, 5 years with Sands Anderson. Long stint as a public sector attorney, county attorney in Goochland for about 8 years. 4, 5, 6 years. Culpeper, further up the highway, assistant county attorney in Arlington County. Currently functions as the attorney for several local governments across the state. He too is one of the instructors that we've called upon for our certification programs as well as other educational offerings. Very pleased to have Andrew with us, and now a partner, I believe. Is that correct?
Yes.
Yes, just elected as a partner at Sands Anderson. Congratulations to Andrew, a well-deserved accolade. Andrew does a number of things in terms of our modern technology, in terms of the, of course it went blank, the Virginia government law, what's your web?
Virginia local government law.
Blog, exactly. So, and you can pull that up, and it's an interesting discourse that you can follow along and look at. And to Andrew's left, David Stoner. David, obviously a partner with Sharon and her other colleagues with Brehan Taves, and he is about 14 years, I believe, experience as assistant county attorney in Fairfax, and he's also had private sector experience, but primarily in the arena of land use and law, and he's in the Chantilly office of the firm. The challenge for the group and then for us is to look at these significant land use rulings. Hopefully everybody has a copy. It's a yellow handout. It's single-sided. The way that we're going to be doing this is according to the outline that you see. If you turn to the first page, it provides an introduction in terms of how we settled on the respective cases. And they're thematic in that we're going to begin looking what the Virginia Supreme Court in these past 14 years has had to say about the Dillon Rule when it comes into play vis-a-vis planning and/or zoning. We also are looking at legislative decisions and the fairly debatable construct or standard that is used by Circuit and Virginia Supreme Court in arriving at a judgment. Notice requirements under 15.2.2204 is a subset of cases as well. Subdivision law, regulatory takings is another item, and what constitutes as an unconstitutional condition that may rise to the level of regulatory taking. Third-party challenges to land use decisions. Who is an aggrieved party, if you will, that has standing? And then variances that typically would be the province, or is the province of the BZA, and then vested rights are the general themes that the panel settled upon. And from that, we will now begin the presentation, and we will start with the Dillon Rule and the Marble Technologies versus City of Hampton. And that's Mr. Hampton. Everybody get a handout.
Good morning. It's obvious that my background is not in marketing because you never begin a presentation by saying, we're going to start with the discussion of the Dillon Rule, followed by a fairly debatable test. So put a smile on your face because the Dillon
But the presentation can only get better from there.
I am enjoying talking about the Dillon Rule because it's an interesting thing that we have in Virginia and a few other states. And those of you not familiar with it, it's a rule of strict construction as to localities, governing bodies, powers. We can only do what the General Assembly has expressly told us we can do, or what's reasonably implied, or what's necessary in order to exercise our power. The two cases that are important in 2000, since 2000, were included in this outline because the Virginia Supreme Court is starting to do a really good job of laying out how that rule is supposed to be implemented and how it's supposed to be analyzed. And it's making it easier for localities in figuring out whether or not they have powers, and hopefully it's providing better guidelines for the trial courts when they evaluate challenges to the local governing body's exercise of authority. So the first case is Marble Technologies versus the City of Hampton. It's a very simple case. Under the Chesapeake Bay Preservation Act, localities subject to that act are required to include wetlands protection measures in their zoning ordinances. And for particular pieces of regulation, the act requires that the locality apply a state criterion. When the City of Hampton amended its regulations, they adopted a federal standard. And that was challenged because the federal standard was more inclusive, and Marble Technologies property became subject to the regulations because the city was imposing the federal criterion. Under the state criterion, they would not have been subject to it. So they challenged it under the Dillon Rule. And the key thing that we learned from the Dillon Rule is that the enabling authority in this case expressly said, localities, you apply the state criterion. When the state tells a locality how they are supposed to exercise their power, that is the only way in which the locality can exercise its power. For those of you who are not subject to the Chesapeake Bay Preservation Act, and those of you who are, the outline includes a number of regulations in the planning and zoning statutes where the General Assembly has said, when you exercise this particular authority, if you're going to do cluster developments, if you're going to do transfer of development rights, and some other things, this is how you do it. And those statutes end up being very long. The reality is a lot of those regulations, because they are so detailed, localities like Albemarle County, we throw up our arms and say, this is too complicated, it doesn't work, we're not going to do it. But that is the only way that localities can exercise their power with respect to those particular pieces of enabling authority. Second case I'm going to talk about is Sinclair, near and dear to my heart because it's one that I litigated and it's one that I lost. Prevailed in the trial court, lost in the Supreme Court. I guess I should throw out some kudos to the Supreme Court Clerk's Office because the name Albemarle County does not show up in the style of the case. New Singular Wireless is the named respondent in the case. That case is unique also for the fact that a locality and a wireless company were on the same side in a piece of litigation. But this case is interesting because it was a Dillon Rule case. But when we got to the Supreme Court, what was going on in Dillon? We had a wireless company, or Sinclair. What was going on in this case was that the wireless company had found a site in a rural subdivision, but they needed to disturb critical slopes greater than 25%, and they needed to get a waiver. And under our long-standing regulations, those regulations required that the waiver be approved by the Planning Commission. The total area of slopes to be disturbed was 408 square feet, so roughly a 20 by 20 foot area needed to be disturbed. And those slopes just barely exceeded 25%. They were 26 to 27%. Neighbor objected and brought a lawsuit, and he said his complaint alleged that the critical slopes waiver was actually a variance. It was subject to the variance standards, including a finding of undue hardship, and only the BZA can grant a variance. The Planning Commission did not have that authority. The county prevailed in the trial court. When we got to the Supreme Court, the case turned because it became an issue of whether or not the Planning Commission had the authority. The courts looked at all of the enabling authority for statutes for planning commissions, concluded that the General Assembly had not delegated planning commissions to make zoning decisions, and the court construed this to be a departure from the applicable zoning regulations, and therefore the Planning Commission did not have the authority to grant that power. The plaintiff had never alleged that theory in the case. So for those lawyers out there, when you are in the Dillon Rule case, or where you think that there may be a Dillon Rule issue, you cannot rely on the fact that the plaintiff has not pled a violation of the Dillon Rule, because the trial court or the Virginia Supreme Court will look at that as a first question: does the locality have the power? And they will stretch beyond the pleadings if they conclude that the locality does not have that authority. Now I will turn it over to...
Well, just a minute, if I might, because Mike said he's coming back, so I told him we wouldn't behave ourselves. Or just the opposite. Should we be left with the impression that the Supreme Court has said that localities do not have broad zoning powers from these two cases?
No, I would not reach that conclusion. For Sinclair, I would conclude that planning commissions do not have broad zoning authority. Their authority is limited to making recommendations on legislative matters, such as the comprehensive plan, zoning text amendments, zoning map amendments, and special use permits. But beyond that, for planning and zoning matters, their authority is limited. And now we can conclude after Sinclair is that planning commissions are lumped into the other statutory bodies where the court has clarified, BZAs, for example, and now planning commissions, that the Dillon Rule does not apply to them. These bodies are statutory bodies, so they only have powers that are expressly enabled. Governing bodies under the Dillon Rule, their authority expands a little bit beyond express enabling authority, but to include those powers that are necessarily reasonably implied and those that are necessary and essential. For example, if the power to perform a particular act is granted, the implied power is the power to enter into a contract that allows you to exercise that power.
Thanks.
Good morning. I'm with you on the next couple of cases. The first one is the McDonald's case out of Fairfax County in 2001. For you attorneys out there, and I know there are a few of you, McDonald's is a testament to the power of your conviction and your courage as an attorney representing a locality in a court with a hostile judge. On December 8, 1997, the Fairfax County Board of Supervisors considered 3 separate applications involving 3 existing fast food restaurants. All 3 applications were requesting approval to add a drive-thru to each of those fast food restaurants. The board approved 2 of the applications. It denied the third one. You might guess that the third one was for McDonald's. The most interesting aspect of this is that one of the other 2 applications, one of the approvals, was for a restaurant that was essentially across the street from the McDonald's, just down a few yards. In the same village center, nearest to the same intersection. And remember, the approval and denial happened on the same day. So perhaps it's not surprising that McDonald's felt a little discriminated against, and that was the basis of their challenge. Rather than challenging on the sort of basic ground of you've acted unreasonably because my existing use is unreasonable and my proposed use was reasonable, which is how typical zoning challenges are considered. McDonald's, recognizing that it was going to have a hard case trying to argue that its existing fast food restaurant was an unreasonable use, said, no, the board acted unreasonably because it discriminated against us. It treated us less favorably than it did these other 2 applications, which were similarly situated. At the trial level, the judge was very heavily disposed toward McDonald's. I can say that because the attorney representing the board was my partner, Randy Grehan. Perhaps his most difficult trial because from day one, he had a judge who made it clear he really was, he'd already decided the case. And wasn't really interested in hearing the evidence that the county wanted to put on about the differences between the McDonald's site and the other. And in the end, that's how he ruled. The sites were similarly situated and there was no basis for the board to have treated them differently. The Supreme Court saw things differently. It explained first that not all discrimination is unlawful. Yes, discrimination can be evidence of unreasonableness, but the key in a zoning discrimination case is first, was there differential or unfavorable treatment of one site, one party? Second, were they actually similarly situated to someone who was treated more favorably? But even that is not enough. If there was a rational basis for treating the 2 sites or 2 parties differently, that can still be justifiable. But here, the Supreme Court, and we should all be grateful for this, the Supreme Court didn't even get to that third prong, was there a rational basis for this discrimination? It was, were these properties actually similarly situated? Even though 2 of them were essentially across the street from one another in the same village center, near the same intersection, asking for the same use. That was not enough. Why? Well, one, the McDonald's site was on a single-use site of an acre or so. The other was part of a shopping center. One, McDonald's had direct access to the street. The other did not. It had an internal series of service drives and travel ways and had more points of entrance and exit by virtue of being associated with this larger shopping center. Trips per day were different. And there were other distinctions, but those were significant. The trial judge hadn't seen those differences or had not thought they were significant. So, and then the most significant difference, of course, was that the other fast food restaurant was a Burger King, and their burgers are char-grilled. Yeah, the Supreme Court didn't say that. We can read between the lines. The lesson we take from this, though, is that don't assume that uses or proposed uses that appear on their face to be similar are in fact similar. Look for the differences. Are they material differences? The next case.
Before you go on,
Yes.
As a local government attorney, I just love the McDonald's case because it seems to put to rest really any claim of discrimination between different, particularly legislative zoning decisions. And I also think back to I think they were both Fairfax County cases, the Allman and the Williams cases from the 1970s. And those were big rezoning cases where the court in just very sweeping language said, well, the denial of the rezoning that was at issue was invalid because the board of supervisors had approved these other rezonings in the same area of the county. Very little discussion about the difference in facts. This reflects a change in the court's recognizing the separation of powers, but since you were in Fairfax County at the time, and I don't know if you know who was around during the 1970s, but there's also, was there a better preparation of the legislative record and a better preparation in presentation of the case in court that has made the job easier for the courts?
Well, I think the bigger difference is that the courts themselves have been more conditioned to favor local governments over the years. I see like the 1980s and 1990s as sort of the Middle Ages. Before that, the prehistoric times, the 1970s, and before, Allman and Williams were products of that age, when the Supreme Court said one thing, the language, if you look at the principles articulated by the Supreme Court in those older cases, sounds good. But when push came to shove, and they actually looked at the facts of a particular case, they almost always saw things through a different lens. And there was more disconnect between the principles they were saying they were following and what they were actually doing. I think the Supreme Court has become certainly much more deferential. And I think that the trial judge in the McDonald's case was following more in the lines of Allman and Williams, and ignoring the 20 years that had passed in between.
The court has been evolutionary in its thinking, and part of that is the good work of not only the legal counsel at the circuit level, but I would dare to also suggest that the good work of the local planning commission and the planning staff, bringing to the court's attention that there is a difference in terms of the location, the turning movements, those sorts of things. And that is what I think is critical when we look at this more modern era. As David suggests, time permitting, we'll look at, I think I would like to give my panel mates a view, but there's sort of three distinct eras in the Virginia Supreme Court history, if you will. And part of that is the Dark Ages, as suggested, and that Dark Ages is not really a negative. It's that the court was, from 1948 to about 1980, was quite deferential to viewing almost a single construct from the purpose of zoning to generate revenue as the determining factor in land use rulings. In post-Lerner case, which is one of the classics, the court has seen fit to go in a different direction, and they've been on that same trajectory for a third of a century. Now, let's go back to David.
Yeah. I'm gonna,
Well, one other point on that, that's certainly true. When you're dealing with a case at the trial court level, it can be won or lost based upon the evidence that's introduced. As David said, the judge wasn't particularly interested in hearing the distinctions or the evidence of distinctions, but the fact that Randy made a point of entering those things into evidence was critical, because ultimately, when it got exposed to the legal standard at the Supreme Court, then the local government was to prevail. Same thing happened in a case in Chesterfield called the Gregory case. Came right, a few years after the Reed's Landing case, and which was a Crawford case. And a lot of folks thought that they were fairly similar in facts, but what really made the difference, in my opinion, was the fact that the counsel in the Gregory case later made a point of putting into evidence the distinctions between the properties and putting into evidence the things that allowed ultimately the court to rule in the local government's favor.
if I recall, the McDonald's case was a week-long trial, so it was a week of hell for Randy. But he persevered, he made his record, and it ended up making the difference. I'm going to cut to the chase for Robertson, just so we can get through the other cases. The next case is Robertson, 2003 case, also out of Fairfax County. The key thing to take from Robertson, I think, is not so much the general discussion of the fairly debatable standard and the fact that a battle of the experts, actually some cases shouldn't turn into a battle of the experts, which is what the trial court viewed this case as. If it's a battle of the experts, the locality wins. The key thing to take from Robertson, I think, is actually lodged in a footnote. The footnote says that essentially because in that case, the property owner wasn't asking for a rezoning. They were simply asking for a proper condition amendment that would allow a deviation from a 200-foot noise setback. So they could put up 4 single-family dwellings. Because they weren't asking for rezoning, an increase in density beyond what was allowed ordinarily in that zoning district, that the court was not to look at whether the existing use of the property allowed by right was reasonable. That was actually, although this is stuck in a footnote, I think that was a change in the law, signaled a change in the law, because the case that it cites, the Harrell case from 1988, was a case, special exception or special permit was sought. There was already a convenience store on the site. They were asking for approval to add a gas station, sort of like adding a drive-through. And the Supreme Court said the denial was reasonable. Why? Because the convenience store you can do by right is a reasonable use. Well, that's not the case with Robertson. The Supreme Court, while they ultimately rule in favor of Fairfax County, it's not because the by right one single-family dwelling is a reasonable use. It's because in the battle of the experts, the plaintiff actually hadn't made the case that he was going to mitigate the future noise impacts of the adjacent Dulles access road. And so the court was justified in saying no. So what I take from that, though, is while this case has not been cited for this proposition yet, I'm surprised it hasn't, but I expect it's going to be. I could see it being raised in the context of a special exception, a special permit amendment, or application, where there's a denial, and the landowner says, I met all your requirements for this special exception. And therefore, the mere fact that what I can do by right is reasonable isn't enough to support your denial. We're going to see that. So just be on the lookout for it.
And we may have a question from the audience involving the construct of special exception and whether or not that can be abridged by an act of the local legislature. In other words, we don't want any more special exceptions in our fair town. Can they do that?
I've been asked to talk about Eagle Harbor and Town of Leesburg, the next two cases in your outline. These are both water and sewer fee cases and not land use cases, and you might ask, why the heck are they in my outline? They are in your outline because they go to sort of the depths of how the fairly debatable standard that David has talked about is applied. In Eagle Harbor, one of the biggest questions, the case was decided on demur. And while there had been no evidence adduced in the case, there had been no trial, there had been no plea and bar hearing, the question was, can a judge throw out a case before trial based upon the pleadings alone and the attachments to the pleadings? The argument by the plaintiff's attorney was, of course you can't decide this thing on demur. You can't throw out my client's case because you need to have evidence in order to make a factual finding like, is it reasonable? And there was a significant sort of disagreement as to, among local government lawyers as to whether that was in fact the case. Unfortunately for the plaintiff's attorney had attached as part of his pleading not only a report from his expert showing the rates in question were clearly unreasonable, but it also attached the rate study that Isle of Wight County had used to adopt the rates. And so the argument on demur was, well, there you go. You've got evidence of reasonableness in the town report. You've got evidence of unreasonableness in the plaintiff's report. And ultimately what happened is the trial judge said, well, I see evidence of reasonableness and unreasonableness, and that is the very definition of fairly debatable. Case dismissed. And so that's essentially how it played out. The Virginia Supreme Court did in fact uphold the trial court's decision on that. And I know a lot of local governments use that in order to try to get cases resolved earlier on the fairly debatable point if they can show that in the allegations of the complaint or in the attachments to the complaint there is sufficient evidence of reasonableness to uphold. The Leesburg case really plumbs the depths of what does it take to actually show some evidence of reasonableness. I was fortunate to file the amicus brief in this case on behalf of the Virginia Municipal League and behalf of the defense of the fairly debatable standard. There was a very big concern. The facts of the case were Town of Leesburg had adopted rates based upon experts' recommendations, but they had told the expert up front, by the way, we want 100% surcharge for those people who use our services outside the town. And so that was the policy guidance given the expert. The expert came back, guess what, with a recommendation that there be 100% surcharge on the rates outside of town. Based upon earlier decisions, including Eagle Harbor, the Supreme Court said, yes, indeed, this is a fairly debatable case, and we're going to review it based upon that. But the real question came down to, was there sufficient evidence of reasonableness? In this case, the circuit judge said no, there was not sufficient evidence of reasonableness because the plaintiffs had a pretty good expert. They had a pretty good argument. And 100% surcharge is a lot. You're talking double the rate outside of town. And while the town really couldn't put their finger on exactly why 100% made sense or why 100% was the right number, ultimately the Virginia Supreme Court overturned the circuit court's finding of arbitrary capriciousness and said that you don't have to actually point your finger to the exact reason why or the exact amount of evidence that sustains it. You just have to have some evidence, any evidence of reasonableness sufficient to make the issue probative. And at that point in time, the courts will step back and let the legislature rule. And that's our form of government. If you don't like it, vote the bastards out. That leads me to the last point in the Town of Leesburg case, and that is in the dissent. Two justices, including Justice Mem, who hailed from Loudoun County, which is an interesting sort of backstory on that. Leesburg being in the heart of Loudoun County, basically had a stinging dissent. And in his dissent, he said, wait a minute, this is taxation without representation. Now, we understand the fairly debatable standard, and it makes some sense. Again, like I said earlier, if you don't like the result, vote the bastards out. Well, what are the poor people out in Loudoun County who don't vote for the Leesburg Town Council supposed to do if they don't like the rate? The answer is they have very little remedy. But the Virginia Supreme Court agreed with the town of Leesburg and agreed with, fortunately, the VML amicus brief that the fairly debatable standard was all they had. And therefore, they were not willing to completely shift the law on that point. They relied heavily on Eagle Harbor and Kingsville and some earlier cases to say that the fairly debatable standard rules, and essentially left the General Assembly. If the General Assembly doesn't like that result for out-of-town people, then they can change the law.
Thank you, Andrew. Notice, public hearing, Cass Martin, Leesburg.
Wow, that's almost as good as the Dillon rule, isn't it? A little bit tough. Actually, these next two cases represent what I think is the relatively new front on which we're going to be defending zoning amendments, text amendments, map amendments, from now on. And that's because, number one, the law changed a few years ago to require descriptive summaries of any zoning amendments that were being proposed. And two, because a failure to comply with notice requirements is death. Your action is void, whatever its substantive merits were, if you don't follow the procedures. What the Supreme Court is telling us overall is follow the procedures in the first place if you want to get the authority to act. So, with that as a preface, let's look first. I'm going to take these out of order because that's how they occurred. Glazebrook, a 2003 decision in Spotsylvania County, involved text amendments to the zoning ordinance. The changes were being proposed to the development standards. That's how it was advertised. The ad read section 23-6.2.4 development standards. Amend development standards for the agricultural A1 district. That was it in terms of the substance of what was being proposed. The Supreme Court looked at that, as did the trial court, and said, well, what are development standards? Well, development standards could mean anything from maximum density restrictions, road frontage requirements, open space requirements, minimum lot size requirements, odd stuff. The basic nuts and bolts of our zoning ordinances. None of that was set out in the act, and the Supreme Court said, not good enough. This was the case that first introduced to us an explanation of what is meant by the requirement of a descriptive summary in our published act. The Supreme Court said, basically what that means is that you've got to have an ad that covers the main points of what's being proposed. Does it concisely. You don't have to get into detail, but you've got to cover the main points to the point where you actually inform people. Because the purpose of the notice statute is to do just that, to inform people to the point where they can know whether they need or want to participate in the public hearing that's being advertised. And when the ad just says amending development standards, there's no way a reader could know without doing his own legal research and going and looking at the actual text of the proposed changes, whether he had any interest in appearing in the public hearing. And the Supreme Court said specifically, citizens shouldn't have to do that. They shouldn't have to do legal research. They should be able to rely on the ad to know whether it's in their interest to show up. So that ad was not good enough. While that case was still pending. Yes.
This legal ad that Spotsylvania post it. It's always bothered me because it leaves me with the impression that they were being intentionally vague as a way to perhaps minimize public opposition. And that's just not a good way to proceed. And the other thought I've had about this case, why doesn't the locality just redo the ad and take new action? Rather than go through this painful process. In the Gasmar case, which we'll get to, exposes that as well.
Yeah, and I think sometimes they do. In fact, in both of these instances, after litigation, they did. And at that point, they hired us to help them in drafting the ads, and they survived.
But when you did what they wanted to do, but they did it better by informing the public in a more direct and substantive and explanatory manner or way. And whether or not by design it was sort of a murky advertisement or we don't want a bunch of people here, who knows? And the court's not going to go there anyway. But clarity now is part of what I think David is the takeaway. And as he explains further in the Gasmar, I think it becomes very evident that this is a new direction that we have to take.
Right, and there are some lessons to take from both of these cases, and both Greg and Mike have touched on them. In Gasmar, yes, got a question.
I wrote that ad. And I remember the conversation with our county attorney at the time. I wrote a short, a medium, and a long ad. And I think the conversation revolved around our concern that the ad would be attacked as being incomplete. And so we felt that the only way, we were downzoning basically the whole world and part of the town. And so we felt that so we really did have to go to the ordinance to see how it would affect the property. And so we said less is more in our case. And it was concluded.
You don't want to be misleading.
Right. And so that was where we ended up. Not to purposely avoid or discourage public involvement.
And again, the takeaway, we need to allow David to proceed to the credit of Spotsylvania. And not only went back and was more of a descriptive and comprehensively so statement, they did follow through in making adjustments in terms of the permitted densities. They did engage in the downzoning exercise. So that's an important takeaway as well. That, they achieved the outcome they were looking for.
And also in their defense, they didn't have the Glazebrook decision with the Supreme Court telling us what is meant by descriptive summary. Not that it's crystal clear even now, because there are judgment calls to be made with lots of ads, but at least now we have some sort of guideline.
If I might, David, and Ray, you will remember when we were doing rewrites of zoning ordinances in Prince William and then also in other localities, we have sometimes counseled to just simply print the entire ordinance with a general descriptive summary on it, and meaning when there's some other limitations depending on reductions in density in certain residential properties and stuff. But we actually, in one case, took out an entire special edition of a newspaper. I think we kept that newspaper afloat that year. So you now know why you will hear the newspapers arguing against just simply putting these online, because it's great revenue for them.
Yeah, that's always a good answer if you can afford it. The other issue is 2204 doesn't apply just in zoning ordinance amendments, applies to comp plan amendments and things like that. I mean, how do you advertise full text of a 1,500 page document with color maps? That gets to be more problematic, which is an issue for another day.
How do you advertise the adoption of an entirely new zoning ordinance?
Working in Lynchburg right now, and that's nearly $30,000 been set aside just for the ad.
That's enough?
I don't know if that's going to, but that's a chunk of change, and I got to Let's let David finish, and unless there's something really burning, let's try to get through the handout and then hold our questions a little less quick.
The next case is the Gasmark case that came out of Loudon. What I'll focus on with Gasmark as a follow-up to Glazebrook. Remember, Glazebrook was about a text amendment. Gasmark involved both text and map amendments. With respect to the map amendments specifically, because that's where I think the Supreme Court really added to the case law to help us in crafting these notices in the future. What they said was, be careful how you describe an area that's proposed to be rezoned. In Gasmark, it was a major downzoning of the western two-thirds of the county. And it was described as, in the ad at the time, as affecting most of the western portion of the county, properties zoned AR1, AR2, A3, A10, and CR. Okay, so the Supreme Court said, in looking at that ad, because it was interesting to note, this particular challenge to the adequacy of the description of the area to be rezoned was not an issue that was raised in the trial court. And I suspect that Judge Horn in Loudon was none too pleased that the plaintiffs basically sandbagged him, raised an issue, they did it with him, and were ultimately successful in the Supreme Court on that issue. We argued against them being able to do that, but they got away with it. What the Supreme Court said was that there were two basic problems with the description of the area to be rezoned. Number one, just saying most of the existing A3, A10, CR properties in the western portion of the county really didn't tell you enough. If you had an A3, A10, or CR property, was that enough? Maybe that put you on notice. Maybe that put you on notice. You should be concerned enough to show up at the public hearing. But the real clincher for the Supreme Court was that, at least the way the plaintiffs spun it and the Supreme Court bought it, the area to be rezoned included more than just the western portion of the county, because of the way the Loudoun County is shaped, following the contours of the running of the Potomac River. Potomac River essentially turns south and cuts off the western portion of the county, so that there's a portion of the county that's western Loudoun County, but it's also the northeastern corner. And that's how the plaintiffs spun it. They said, that's not the western, that's the eastern part of the county, even though the county continues for a number of miles east from there. And the Supreme Court said, yeah, not only is it inadequate when it says most western part of the county, but it's also inaccurate. And so what we take from that, and what the Supreme Court told us, is that when you are doing a map amendment, you need to use geographic boundaries and landmarks to delineate the area being rezoned, and be sure you do it accurately. And so the real lessons to take from Glazebrook and Gasmark are, put yourself in the shoes of the citizens out there who are, it's a fiction, we know, but who are reading these ads. And ask yourself, would this ad tell me enough to know whether I should show up at the public hearing, whether I should be concerned about what's being proposed? And as Sharon suggested, sometimes it will mean that your ads become a little unwieldy. Again, Loudon hired us to help them with the drafting of the next ad that turned out to be successful. This was the ad, and if it looks small to you, it looks small to me too. the print that is. But there was a map that accompanied this, so it wasn't just all this text, but there was a map that delineated the areas proposed to be rezoned. So in addition to the actual geographic descriptions, you had the map to supplement it. So, as I said, this is a new frontier in a sense for us. I expect that almost any challenge you see to a zoning ordinance or map amendment is going to include a challenge to the notice, whether it proves to be successful or not, because the upside for the plaintiff is so great if they win on that, and the standard is so high. We're just going to see it, so be careful. And also include your local attorneys in the drafting of these ads. Work together with them. You can cover each other.
Yeah, what David was just saying, in Albemarle County, after Gas Smart in Glazebrook, and since then we've been working with our Department of Community Development to update the templates to make sure they satisfy the requirements of 2204 and 2285 for the zoning actions. And our office handles the ads for the text amendments, so that's all on us. And I'm always very mindful of these cases and what 2204 requires, but so far that's worked pretty well.
Tetra?
The Tetra Builders case, which is on page 7 of your summary, sends again the very strong message from the Supreme Court that you don't use your subdivision ordinance to make zoning changes. And that is a message that has been sent a couple of times just prior to the Tetra Builders case, which came out of Chesterfield County. There was a case called Countryside out of Augusta County. And there have been some circuit court cases since then. I'll touch on one of them for Debbie Kendall's benefit. She was my assistant. We were doing this for Orange County. But the Supreme Court has made it pretty clear that you don't try to go and use the subdivision ordinance as a shortcut for amending the zoning ordinance. Some localities still haven't gotten that message, and I think one of the problems is that they go, well, we were required to have a subdivision ordinance, and we don't really like zoning. Or people don't understand zoning, or oh my gosh, if we touch that zoning ordinance, it's going to be really awful and I will not get reelected. And so there are huge responses, more usually than there are on subdivision ordinance changes. And so the local government officials look at that and they go, we just don't want to go through that pain. So let's amend our subdivision ordinance. And oh yes, planning office, county attorney, city attorney, we'll get to the zoning ordinance, so don't worry about it. We're going to get to it right after you do that subdivision ordinance. And we have all the pain of doing the comprehensive plan, so we're moving along. And as you know, it's very difficult to accomplish amendments that make all of those documents consistent. The comprehensive plan is your plan, the zoning ordinance is your legislative document, and then your subdivision ordinance as your basically administrative ministerial document. So when you look at Tetra Builders in that case, in Chesterfield County, the zoning ordinance allowed for 1 acre lots for the particular area in which the property was located that Tetra Associates wanted to develop. And they came in with a plan that showed 1 acre lots, and the planning office said, oh my gosh, no, you can't do that because our subdivision ordinance says for that particular zoning district, you need to have 5 acre lots. And in essence, what they wanted to do was to force Tetra Associates to come in for a rezoning in order to get to the 1 acre lots. And as you know, with rezonings, there are opportunities for things like proffers. There are opportunities to consider legislatively whether you want to approve or deny it. And the standard, as David's pointed out, is a higher standard and fairly debatable. So the Supreme Court looked at it and said, no, you can't do it. You can't say, oh, we've got great authority under 15.2, 2200 to define subdivisions, so we can define subdivision in a way that basically amends our zoning ordinance. Can't use the definitional section that way. Can't use the general subdivision authority in 15.2, 2240 through 2242. And the court really didn't talk about 2240, and I'll get to that in a second, but it definitely said that 2241, which sets forth the mandatory provisions for subdivision ordinances, and then 2242, which allows for the optional provisions, are where you look to see if you have subdivision authority. And it took off on the Countryside case, which was clearly a Dillon Rule case in which it said simply you don't have authority to do this. You can't simply use your subdivision ordinance as a means of rezoning. The decisions, both of them, are a fairly rigid adherence to the Dillon Rule. And does it affect the processes going into the future of these localities? The answer is yes. You can't take the shortcut approach, but in a more positive land use way, if you start with a comp plan, then you sync it with your zoning ordinance, and then you sync your subdivision ordinance to your zoning ordinance and comp plan, you probably have better planning. But the message that was sent in the Tetra Associates case, as well as in the Countryside case, was a fairly chilling sort of, no, you can't do this. And in both of those cases, there really is very little sympathy for the local government when the local government attempted to do this. So you go back and you get to the issue kind of, what happened at the front end? Why did the locality do this? How did their county or city attorney allow them to do this? And, obviously, city and county attorneys can't talk about the legal advice that they give in confidence to their governing body, but a letter to the editor from a former supervisor who was running for re-election, or on behalf of somebody who was running for election, stated in a circuit case, not the Tetra Associates case, but in a circuit case that went off on similar issues, that the county attorney told them not to do it, but they did it anyway. So there is a huge political aspect of this that needs to be considered, and oftentimes both you as planners, the attorneys have to fight against that to say, no, you can't do it the quick and dirty way. You've got to go through the process and do it in a way that puts the subdivision ordinance in the proper role. The one thing that's not clear in any of these cases, and for those of you that still might want to venture into these waters, is whether 15.2-2240, which is a general introductory section on land subdivision development, is simply not being considered by the courts. It hasn't gone up to the Supreme Court really, and that section is quite broad. It says the governing body shall adopt an ordinance to assure orderly subdivision of land and its development. And if you were to read that as broadly as you might read 15.2, 2280 and 2286 with respect to zoning, you might be able to hang your hat on that, but the better approach, I think, both from a legal and planning standpoint, is to go through and follow the course of comp plan, matching zoning ordinance, and matching subdivision ordinance.
Thank you, Karen. Andrew?
All right, now we're going to talk about my former employers in Culpeper County. I'm glad to see John Ayerson, the planning director here, who is quoted extensively throughout the opinion, so you can ask him for all the dirty details later. Greengale was a very interesting case from a lot of perspectives. It ultimately ruled against the developer's arguments in favor of the local government. I always like those cases because my clients win. In this case, we had a major residential subdivision coming down the road in the county just outside the town. The county decided to amend their comp plan to designate that whole area that was zoned for high-density residential to an industrial designation, light industrial, LI. Developer came in and was turned down for their subdivision approval, saying, well, I've already got R4 zoning, I get to come in and hand you my subdivision plat and I get approved. The problem is the subdivision ordinance for R4 required water and sewer availability. They didn't actually have water and sewer availability. They had the expectation that they would get it. Some nearby properties had it. The town had given arguably similarly placed places just outside the town on the other side of the bypass water and sewer. The county officially had no formal position on it, but ultimately the town turned them down for the letter, or at the very least drugged their feet and just didn't give it to them. There's some very interesting issues come out of this. One is the subdivision issues, and that is when you buy a piece of property, you're subject to the regulatory scheme that is there. Essentially, buyer beware. They allege that there was some sort of taking, saying, well, I've got an R4 zone, I've got the right to develop all these houses, you can't take that away from me. But in fact, you're subject to the regulatory scheme that's in front of you. They never had water and sewer availability from the town. They thought that they could get it, but they didn't ever actually have it. Therefore, it's not a taking. The zoning issues, I think, are even more interesting in my perspective. A number of really good holdings out of here for local governments. The trial judge actually overturned a subsequent rezoning of the property. After they turned the subdivision plat down, the board rezoned the property to light industrial and said, well, we're following our comp plan. There were several things out of that. The trial court actually overturned that and said that was inappropriate and overturned the zoning because of a vested right. And the Supreme Court said, well, you actually can't stop somebody from rezoning because of a vested right. I mean, that's kind of the definition, isn't it? They rezone and they have a vested right notwithstanding the rezoning. So that was one sort of kind of interesting point. The Supreme Court reiterated the point that a general zoning category is not a significant affirmative governmental act. It's not for a specific project. It's not for a specific site, specific approval. It was just R4 zoning that's applied to a general area, including the property, so therefore that could not give rise to a vested right. And then also, the local government, of course, had upzoned the property consistent with the comprehensive plan from R4 to light industrial, and there was a significant issue regarding whether that was a upzoning, as the county argued, or a downzoning, which is what the applicant was arguing. And of course, as you are aware, we talked about the fairly debatable standard that applies to almost all zoning decisions except piecemeal downzonings. And so they were arguing it was a piecemeal downzoning. You took our property and you downzoned it. It was piecemeal. And the Supreme Court rejected the developer's argument that, you took my property, it was worth a bunch of money as R4 apartments, and you took it into light industrial, which there's no market for right now, and there's no way I can make a bunch of money. So you basically cut my value in half or maybe by 3/4. The Supreme Court said that's not the standard for what is a downzoning. You can't expect courts to go into a profit analysis and have economists on the stand and determine, what's the market, etc. It's purely a use-based standard. So if you're ever defending a piecemeal downzoning argument, you need to look very carefully at the intensity and the density. And that's what the Supreme Court held was not proven in that case, and therefore was not a downzoning.
Thank you, Andrew.
And the rejection of the profit expectation theory for determining whether zoning is a downzoning, it's a significant decision. It's been helpful for Albemarle County. It also cleans up some older cases where the court had looked into the profit expectations of the developer and decided whether rezoning was a downzoning. So Michael sent out the email inviting us to be on this panel to discuss recent Virginia Supreme Court cases. I waited to see who was going to throw out the first idea, and I think it was Andrew who said Kuntz. That's on page 8, and if you look at your outline, you'll see that the citation to Kuntz is a little bit different, because right after the style of the case, we have 570 U.S. This is a United States Supreme Court decision. This is an aberration in this presentation. And
It was decided through consensus to put it in here, and Greg will now give you that overview and a few takeaways.
A few takeaways mainly. You can read the facts of the case. Essentially what happened was that Mr. Kuntz Sr. wanted to develop his near 15-acre piece of land at an intersection in Florida, and he had to get 2 permits from the Water Management District in order to do so. And the district required certain conditions that would have extremely limited his ability to develop and also to pay cash to do some remote offsite improvements. And then he didn't want to accede to those conditions, and so the Water Management District denied the permits. And Kuntz sued the district. And it bounced around in the Florida courts for years, and Kuntz Sr. died in the process, and his son carried on the case, and it eventually made its way up to the United States Supreme Court. There are 2 key issues that were resolved in this case. The first is that it extended the exactions analysis of Nolan and Dolan. I'll assume that you know the Nolan and Dolan standards, and I'll get to those in just a moment, to monetary conditions, because around the United States, some courts have said no, some courts have said property is only real property. It doesn't extend to monetary conditions. You cannot have a taking, or the takings analysis does not apply when you're dealing with monetary conditions. It also extended the application of the exactions analysis to those cases when a public body denies a permit. That was what was a little bit unique here. And what Chief Justice Roberts said was that conditions that result in a taking are unconstitutional, even if they're not imposed, because under what he called the unconstitutional conditions doctrine. And the analysis is the same, whether or not the project is approved with those conditions or whether or not it's denied where those conditions were a factor in the decision. So that's a key, those are 2 key points. The part I'm going to talk about is that a lot of these issues were already resolved in Virginia. First, we have the Roe case, which Roe versus James City County, a 1975 case. Way back then, the Virginia Supreme Court said that money was property. So that issue was really already decided. And then we also have the Cup case, and we have the Bynum case, where conditions have to be reasonable. Even if the locality approves a project, those conditions have to be reasonable. So far I'm talking about conditions, and we expanded over to proffers, because proffers are really nothing more than conditions. And the state law for proffers, if you as a locality are adhering to the state requirements, both in the statutes and in the existing decisions from the Virginia Supreme Court. On the proffer side, proffers have to be reasonable conditions. Not on the constitutional side, unconstitutional exactions. The rezoning related to proffers has to give rise to the need for the proffers. On the constitutional side, that's speaking to the requirement for an essential nexus. The proffer needs to be addressing an impact from the rezoning action. Last, the proffers have to have a reasonable relation to the rezoning. That's the rough proportionality part of the exactions analysis under the Constitution. You can't, we'll use the Cup case in Fairfax County as an example. They had a special use permit for to allow a nursery or garden center, and their project was going to have a minimal impact on Route 7. Route 7, I think, at that time was a 30,000 vehicle trip per day, and this proposed use was going to generate approximately 125 vehicle trips per day. But the county wanted the owners to dedicate 100 feet of frontage from the center line because they had plans to expand Route 7. cut precedes the Knowlton and Dolan analysis, but the Virginia Supreme Court was right on. They said that, not using the same language, but essentially the condition that was requiring that dedication of the 100 feet lacked rough proportionality because the traffic impacts resulting were minimal compared to the overall condition of Route 7. So in Virginia, we should already be there. Your conditions already should be reasonable. There should be that nexus of rough proportionality as you're developing conditions or you're negotiating proffers. The last thing I wanted to talk about, two last things about Koontz, is that in Koontz, the U.S. Supreme Court left an out. As long as the locality provides an alternative condition that is constitutional, there's no exactions analysis required. The locality has satisfied Koontz and the Nolan and Dolan test. The other thing is that the remedy in these kinds of cases where you have a denied approval with this condition, unconstitutional condition that's lurking out there, is a state remedy. In Virginia Code Section 15.2, 2208.1 is a new piece of legislation that will take effect, providing the state remedy effective July 1st. One thing about that is that there's a safety valve for localities because before the public hearing, the applicant has to file a written objection to that condition. My recommendation would be at that point, you stop the process and try to clean the record.
If I might, just two things on that. One, I think at least in the short term, you're probably going to hear some irritated developers yell Koontz to you. I know I was at a session recently up in Prince William and somebody felt compelled to talk about the case. And if you hear that, you should go and talk to your city or county attorney and let them know that that's been alleged, because there are, as Greg said, some implications if it's an unconstitutional condition under this new state legislation. But to put this in perspective, you will recall after Nolan and Dolan, a lot of people went around and when they got upset with you, they said, this is a takings. And you know, the public hearings were replete with concerned property rights people saying, these are takings, this is what you're doing. Well, the question really was, are they illegal takings? And the answer, bottom line, is that in Virginia there is almost no law in which, and there is no law to my knowledge, in which there is a finding that a zoning regulation constituted a taking that was compensable. So we need to kind of put this in perspective. You need to be alert and attuned to it. You need to talk to your legal counsel, but you shouldn't necessarily freak out. The same is kind of true with this new section of the state code. And it was touted as being a result of Koontz, although Koontz was under Florida law, and as Greg has indicated, we do have explicit proffer enabling legislation. But under this new statute, it says you cannot impose an unconstitutional condition. Well, I hope you're not doing that now anyway. So the issue makes you a little nervous, and it's got a chilling effect because you're going to wonder more, looking over your shoulder, do I face the possibility of attorney's fees and damages and those types of things? And what do I do? An applicant suddenly says you have an unconstitutional condition, which they've got an obligation to let you know. So I think watchfulness is important, talking to your legal counsel, but don't necessarily think that the sky is falling in and you can't do any land use regulation.
Very good point, Sharon. We'll go now to the alleging standing to sue.
Standing is a preliminary jurisdictional issue. And so in every single zoning case that comes in and challenges something that you were doing, that's the first thing that as counsel I would do. Well, what is their standing? Do they even get to file this? If there's no jurisdiction, the case is at an end. One of the cases cited at the very bottom of the discussion there, the Deerfield versus City of Hampton was one of my cases on behalf of my client, City of Hampton, the zoning administrator there. It was very nice to be able to stand up in front of the Virginia Supreme Court and say, this is a preliminary jurisdictional issue. You get to decide this, and the other issues don't matter. And there was a bunch of justices nodding their heads. And so, I mean, it's very nice to be able to make a standing argument. Friends of the Rappahannock was litigated by my colleague at Sands Anderson, Ann Neal Cosby. Many of y'all know Ann Neal. She also speaks to a lot of groups through Plain, Virginia, and the LUAP. Facts in Friends of the Rappahannock are a sand and gravel operator came into Caroline County, got a special use permit, or conditional use permit there in Caroline County. Sands Anderson serves as county attorney to Caroline County, so we were making the advice throughout of all this. The question really goes to standing is what is aggrieved, what is particularized harm, etc. A lot of attorneys and planners and others that considered this issue in the past said, well, if you're adjacent, that's sufficient. If you're next to the property that's being rezoned, after all, the statute requires that you send notice to these people. If they don't like it, sure as heck, they get to go into court and challenge it, right? Well, this case says no, that's not sufficient. Being adjacent is not enough. You've got to show some particularized harm to your use of your property. Beforehand, everybody had agreed that if you're not adjacent, you got to show that, because then you got to show some real actual impact, like the Charles City County landfill case, for example. They weren't next to the operation, but they had allegations of particularized harm. I spoke to Judge Ellis, who was the circuit court judge in the Friends of the Rappahannock case recently on a standing case, and in his view, what this case stands for is you've got to allege actual harm from that use to you right now. And that's his view. It's not some, hey, I think it's going to happen in the future, or if they do certain things, it might happen. You've got to allege that this is actually happening to you right now. And that was his view, and I think you can certainly read that. What's interesting is the opposing counsel said, you can't cut it that close, Judge Ellis. And Judge Ellis said, that's exactly how close they cut it in that case. So I guess the lesson and the takeaway from here is, it's difficult to sue the sovereign. It always has been. It is now. A preliminary jurisdictional issue is standing. Like in Deerfield versus City of Hampton, you've got to show your power to bring suit to sue the sovereign. Like in Charlottesville Operator, which is the YMCA in Charlottesville and Albemarle case, you've got to show that the statute actually authorizes suit under that statute, in that case, the Procurement Act. And so all of those stand for the proposition that just as closely as the Supreme Court will review your authority under the Dillon Rule or your advertisement under 2204, they will also look very closely at a plaintiff's standing. And so I'm glad to be able to stand up and bring that happy report.
Thank you. Thank you. Miller case, Highland County.
In both land use cases and the other non-land use related cases I handled, Miller is always a go-to case. I always look at Miller and see if the facts justify using Miller in a motion to dispense with the case right off. And going back to the Giordano case, which was the fee case that Andrew spoke about, where again the out-of-towners, they did not have a remedy because they were out of town. They couldn't even vote the town council out if they objected to the fees that were being imposed. And there's a misconception that every kind of land use related decision, there's a remedy for it. And that's simply not the case. And in this case, the Miller case was a challenge to the Board of Supervisors decision with respect to a proposed wind turbine farm and the 2232 review that was conducted by the Planning Commission. And to determine whether the farm is going to be in substantial accord with the comprehensive plan. 2232 does not provide for third-party relief. It allows for the applicant or the developer to proceed to appeal to the board, to the governing body, but there is no third-party right to challenge in court. And there are a lot of provisions in local land use law where that is not the case. There's no third-party right to to challenge subdivision plats, site plans, which are both under the same enabling authority. There's very limited authority for third parties to challenge, for example, stormwater management plans and erosion and sediment control plans as well. So in addition to standing, when a third party is unhappy with the local governing bodies, or in this case, the planning commission's decision, they have to find a statute that justifies, that gives them the right to go into court. And what the plaintiff's counsel in this case cited the declaratory judgment statute, but that in itself is not the remedy. They have to also find the right to the remedy in a statute. And so this becomes a go-to case for us. So what remedy do these people have? And go back to the out-of-towners. They didn't have the right to vote the bastards out. But in most cases, that's what the remedy is. There's some old road cases and old financial expenditure cases going back to the 19-teens, 20s, and 30s, where that's what the court said. There's no remedy in court. The remedy is at the polls to vote the people out if you're unhappy with the decisions that they're making.
Thank you, Greg. We're going to look at variances with Andrew. Going to make it, I think.
I think we're going to make it.
It's getting very close here, but we're going to make it. Go ahead.
Okay. I'm sure most of y'all are familiar with the variance standard. You would have to show an undue hardship. You have to show some kind of severe impact that really is nearly a taking. And I think that one of the important things about the Cochran case is it summarized existing law. I know in the General Assembly after there was a lot of squawking from various people saying, well, see, that it made it much more strict than it used to be. Well, that's not the case. All Cochran did was recite well-known principles that zoning officials and local government attorneys knew about for years. I think the reason they took the case is that it had been a while since they decided a variance case, and the fact was it was being poorly implemented throughout the Commonwealth, or at the very least it was being implemented on an uneven basis. You had some BZAs that were granting variances when there was certainly plainly no undue hardship or confiscation or anything like that. It just would have been really, really nice. And so I think that Cochran stands for the proposition that really, really, really nice is not sufficient. In fact, the case goes into three different fact patterns in three different localities and shows why in each case, the Supreme Court actually says they put forward compelling reasons why the variance would make some sense. And the Supreme Court said, I don't care. It doesn't matter if you have compelling reasons. It matters if you can show the legal standard of undue hardship. And that's what matters. And we're talking undue hardship of a particularized manner, based upon something that cannot be changed, like topography and depth of the property and things like that. Things that go to the core of the development and use of the property. And if they can show that, and that's very difficult to do, because in the end, under the analysis in Cochran, you have to show that they are left really without any ability to develop and use the property. And that is very difficult to do. In each of these fact patterns, out of Fairfax and Pulaski and Virginia Beach, it was shown that under each case, they could have done something by right. It was less attractive. It made less sense. It certainly wasn't desired by the landowner. But in fact, that was insufficient. This right thereafter, I told the General Assembly sort of looked at that and said, well, we need to make a change because of this, strict rule that they suddenly discovered that was in case for variances. And they struck two words from the statute. They struck approaching confiscation after demonstrable hardship. They didn't change any of the other language. They didn't change any of the mandatory findings that are mandated by a BZA to get to a variance. They just struck approaching confiscation. And then the question ever since then was, well, what do they do? And I know I stood a lot of times in your meetings in front of planners and zoners and things like that. People would ask me, what does that mean? And I was always of the opinion it didn't mean much of anything. It doesn't mean much of anything because all the rest of the statute's in there. The statute has about 10,000 words, they struck 2. And as a result, it didn't mean a whole lot. And that's in fact what the facts are and the holding is in the Martin case, which was, among other things, the zoning administrator had changed their minds. They basically turned it down twice. The zoning staff had said, we don't think that meets the standard for variance. And in the end, they said, yes, it does. And their argument was that, well, the statute changed. Well, the Supreme Court said that's not sufficient. A couple other real brief points, and then I'll let us get to vested rights, which I know we won't want to have time for. One thing is that the standard for variance here came not from the statute that was interpreted by Cochran, but from the Alexandria City Charter. And the Supreme Court, in this case, said that they were about the same. And so they essentially used the same standard, and they went forward. Interestingly, they didn't cite Cochran, and that's very interesting, that the very next variance case they decide, they don't cite the preeminent case on the point at all. So that's interesting. But if you have a town or a city, go check your standard for variance. It might just be different. I know I handled a case on behalf of one group in the city of Richmond. The city of Richmond variance standard is significantly different than the one in the statute and grants a lot broader discretion. And in fact, one of the holdings in Cochran is that the legislature can grant a much broader variance if they want, nudge, nudge, but they haven't done it here. And we'll get to vested rights.
Excellent point that Andrew advances with respect to the variance test, and it's an important takeaway, and as some of you know, I'd like to commend those of you who serve on BZAs or suggest that you have the hardest job, because many times the heart is telling you to grant the variance, but your brain is telling you there's no hardship. And the charter that we sometimes ask you about in the certification classes, Andrew gives you good evidence of why it's important to ask the question back home. You don't have to read it yourself, but is there anything in your city or town charter that as a planning commissioner or staff member you should be aware of? Because you may have language in that charter that is demonstrable and apropos and consequential for your jurisdiction, because that charter comes from the General Assembly. And that's an authorized use. As long as it's not in violation of the Constitution, you can do it. Okay, we're going to give it to Sharon with vested rights. Y'all did well.
I would echo that. We do a number of zoning ordinance recodifications, and you need to pay attention and update your zoning ordinance on a regular basis when the General Assembly has taken action in areas such as this. We've basically heard, I think, that the Supreme Court has upheld and been favorable to localities on the standard by measuring their action with respect to rezonings, that the presumption, the legislative presumption has been applied. So the issue of vested rights becomes really critical, because if you are in fact replanning, rezoning, through development of new text in your zoning ordinances, then the question is going to be what happens to those that might be quote-unquote legislatively grandfathered, or are they grandfathered? And so you get to the issue of vested rights. And so a broad determination with respect to vested rights can really just undercut better land use planning that your locality may have been engaging in. So the good news is, from the 3 cases that we cited for you, Board of Supervisors of Stafford County versus Crucible on page 14, the Norfolk 102 case versus City of Norfolk, and Hale versus Board of Zoning Appeals of the town of Blacksburg, is that the Supreme Court has said in each of these, you must follow the vested rights statutes in 15.2, 2307 and 15.2, 2311. If you are a property owner or someone who's a developer of a piece of land and you claim that you have vested rights, you must meet all of those criteria. And so the Supreme Court has been very strong in saying that if you're going to claim vested rights, you have to demonstrate affirmatively that you have met every requirement. The other thing that the Supreme Court may be saying, and I'll be a little humorous about this, I handled the Stafford County versus Crucible case on behalf of the Board of Supervisors. And and when, yeah, Mike was reminding me that Dan Sharon had the unfortunate experience of dealing with a very pushy attorney for a landowner in that case, who came in and sort of said, I know what I want out of this opinion, I'm going to help you write it. And said, yes, this is a school, an anti-terrorist training camp is a school within the meaning of school in your zoning ordinance, and permitted by right in this semi-rural area of the county, which backed onto the property of a former circuit court judge, backed onto the property of an African-American church, backed onto the property of a small McMansion subdivision, and backed onto the property of beautiful rural Stafford County. And so the attorney said, I need to know, is it permitted? The answer was in the zoning letter that was signed, it is permitted, but it's subject to change. The Supreme Court said, well, that really doesn't have the formality of a zoning determination, and therefore you don't meet the first key requirement of a significant affirmative governmental act, a SAGA. And that's where the Supreme Court's going to look first, is can the property owner or developer demonstrate that you have a significant affirmative governmental act? And when I argued this case to get the petition granted, and I said, oh, and Your Honor, here is what this facility will do. It has a driving range, it has an obstacle course, it has a firing range, it has classrooms, and you can learn how to garrote somebody. And the judges looked at me, and the justices looked at me, and I knew they were skeptical about anti-terrorist training camps. We also learned in the Hale case that they're skeptical about bait and switches that end up with Walmarts. And that's what happened in that case, is the property owner in the Hale case used a rezoning that looked like it was going to be an accessible shopping mall, small stores, to come in and say, well, it permits a Walmart. Key thing to remember on that, make sure if somebody comes in as a developer and shows you pictures and shows you diagrams, and you want that to occur, that you get profits. Or if it's special use permit, that you get conditions. In this case, the developer was a little cagey about what they were showing as pictures to the public and to the town council and what they actually were going to agree to. And in that case, the Supreme Court said, no, you can't slot in a Walmart under that. You can't claim that you have a significant affirmative governmental act. You can't claim that you met the other requirements for vested rights, and you have an affirmative duty to do so. In the Hale case, it is instructive, and I really suggest that you take a look at it if you're trying to put together how you are going to defend a decision that there are no vested rights. Justice Kuntz in that case goes at length through all the evidence that was submitted in the case, and we talked about at the beginning and reiterate that you can't do enough in terms of thoroughly documenting what is happening, and we did that in Crucible as well, and I think it made a difference. And then in the Norfolk 102 case, we also found that the Supreme Court is skeptical about establishments that serve alcoholic beverages, particularly in a place known as Waterside. I think we're familiar with it down in Norfolk, where maybe you have problems from time to time with crime, with people getting drunk and creating issues. And so I think you're seeing a little bit of the Supreme Court being cagey or looking at it and saying, you, the property tenant in that case, have to demonstrate that you have that significant affirmative governmental act. You have to demonstrate that you have a determination by the zoning administrator and the planning staff that you can't simply bring in a cash receipt that you got from the zoning administrator acknowledging that some payments were made in order to demonstrate that the use that you want to put your property to, in fact, wasn't allowed use under the prior zoning ordinance. And the court looked very carefully and found that only about 1/6 to 1/8 of one of the establishment's property might have been in the area that could have allowed this particular zoning without a special exception permit. So the court was really going through in some great detail the evidence that was submitted. And again, I counsel you that it's really important to put together your case well and thoroughly at the front end and as early as possible, so that when you go either before the BZA or you end up with the circuit court, or even if it's desirable, candidly, in talking to your zoning administrator as legal counsel, you want to make sure that you outline in detail what the significant affirmative governmental act is, and then what it constitutes diligent pursuit and substantial expenses that might get somebody to vested rights when the zoning ordinance is changed. So the Supreme Court has been very helpful in supporting localities' points that anybody coming in and seeking vested rights once the zoning ordinance is changed has to meet all of the requirements. So that's it.
I know we're kind of out of time, but I've got like three quick.
Yes.
One is, in the Hale case, they were very clear that we're talking about a specific project. And I think the key turning point in the case was the fact that they wanted to reserve flexibility in their proffers. And they specifically said that. When staff said, I want you to be more specific about what it is you're proposing here, they said, no, we want to preserve our flexibility. And the Supreme Court cited that and said, I'm sorry, flexibility is the exact opposite of being specific, which is the touchstone of vested rights. And I think that the other thing that is really significant about the Hale case is what rights vest. I think a lot of us can recite the vested rights standard, and we kind of understand what significant affirmative governmental acts are, etc. But to me, a very interesting question that's not been explored by many cases except Hale is, if you do have vested rights, what rights vest? What do you get at the end of the day? A lot of developers will argue, I get everything that I could have gotten under the old zoning ordinance. And that's not the right answer. The answer is what rights vest are, what did the government approve in the significant affirmative governmental act? And so if they're relying upon a subdivision plat approval, for example, they don't get zoning rights, they get what's under the shown on the plat. And that's it. And so be very careful when developers are arguing vested rights. They may be right, maybe they have a vested right. But then the question is, okay, what do you get as a result of that?
Andrew, thank you very much. I want to commend my panel members for the excellent work that they have done over the past 4 weeks, give or take, in preparing for today's session. Collectively, we were so bold to conclude that once we went through these cases, in the time remaining, we would then review the 10 or 12 classic cases. That work is continuing, and I'd like to think that maybe by the fall, we will have a companion piece that will kind of look at what the Virginia Supreme Court gave us in terms of some of the foundations for what we looked at here today, and see how the court has in fact evolved from where it was in the first epoch or era for land use in Virginia from 1928 with the, or 1926 with the Lori Fox case, a few months after the Euclid v. Ambler United States Supreme Court ruling on zoning, up to 1948, and then 48 to the Lerner case, and then Lerner to where we are today. There are a couple of quick takeaways, and then maybe an opportunity for maybe a question before we go next door for lunch. When you consider what the panel has put together, there are some themes that are captured in the introduction to the materials, and it's important that we maybe go back and revisit where we started. We were looking at process. We were looking at the relationship of actions taken at the local level opposite the Dillon construct. Dillon remains supreme. And Dillon, when it comes to the Dillon rule, when it comes to what we do, what you're doing back home at the local level, must be viewed in that light. It colors, it flavors, it gives character to every action taken. And if you find yourself in a court proceeding, even with the benefit of these wise counselors to my left. The court at some point is going to want to have its inquiry relative to the presence or lack thereof of the Dillon rule per this complaint clearly established. So we can't do anything that's outside the purview of the Dillon rule. Process in terms of notice, very important in terms of what the court is telling us and sharing with us, to do it the right way. And that applies to notice, that applies to all manners of how you do your work, both as a staff and as a commission and as a governing body. The third party challenge, the whole notion of standing. The court has shed considerable light on that subject. The subdivision law, as a standalone component, as Andrew just indicated, and how far we can go with that in its relationship as standing in terms of a saga. The regulatory taking, further evidence of what we in Virginia, not noted as a state that tends to be a bellwether state for planning and zoning, but to our collective credit, or to our state's credit, our Supreme Court has been doing some things pretty darn well in relation to what the U.S. Supreme Court has been advancing over the last quarter century or more. And then the whole arena of variances and vested rights. More light shed on those two topics, making maybe for, again, those of you who serve on BZAs, an additional challenge in terms of the head versus the heart. But the idea that the variance is something that one's not entitled to. One has to show almost the absolute loss of a right or an enjoyment of said property. Thus, again, making your job altogether challenging. And then the vested rights construct, again, valuable for us to consider when that occurs and whether or not that has a consequence for our action at the local level. We have a lot of guidance from the court, and I think our panel members today have provided some insight. Is there a question for our panel? Maybe one. Mr. Weinberg, an attorney. Yes, sir. Please come forward.
I have a question about the Dillon rule, which
Yes, sir.
discriminates so much against localities in Virginia, unlike 48 or 49 other states. My question is twofold. First, how did that rule come to be adopted in Virginia? Is it just a judge-made rule, or is it a rule adopted by the General Assembly by statute to enhance its own powers?
I'll make a quick comment and turn it to my colleagues.
The second half is, how do we get rid of the Dillon rule? The public and the localities want to get rid of it.
On that point, the Dillon rule is not found anywhere in the Code of the Commonwealth, to my knowledge, nor will you find it anywhere in the Constitution of the Commonwealth. Dillon rule is a construct of jurisprudence that comes into play with the court. Take it away, boys and girls.
It's named after Judge Dillon.
A real guy.
He was a real guy, and he made a decision that state law had to be supreme over local government law. He was facing a situation under which railroads were trying to get through the country at that point in time, and the railroads were not happy about local government regulations about where their tracks were and what their operations were. And so the railroad said, you know, we really would rather go to the state legislature and have these things ironed out so we can move the commerce of America. And Judge Dillon essentially come up with this legal construct to say, yes, you don't have to pay attention to what the local governments are saying unless they can trace their authority directly back to what the state says they can do, thus shifting power from local governments to the state level. And that was very, very popular with the railroads and subsequently with phone companies and with a bunch of other folks that liked going and lobbying the General Assembly.
He was not a Virginia judge.
No, he was an Iowa Supreme Court justice.
Let me offer a quote from Judge Dillon. This is from a 1989 article in Virginia Town and City. Justice Dillon was on the Iowa Supreme Court. He was Chief Justice of the Iowa Supreme Court in the mid-1800s. So that's the context that Andrew was referring to. But what Justice Dillon wrote was, quote, "Those best fitted by their intelligence, business experience, capacity, and moral character," end quote, did not go into public service. He felt local government was, quote, "unwise and extravagant," end quote. That is the perspective that he had based on the corruption in local governments that was taking place After the Civil War.
1870s, 1873 treatise on the powers and authorities of municipalities is the genesis for the Dillon construct, and then as applied as a jurist and a member of the Supreme Court in the state of Iowa, he advanced the reality that governments, local governments, have only authority to do what has been expressly authorized, which it means you find it in black and white in the Constitution or the state code. He also had a second rule that the Virginia Supreme Court hasn't found favor with, and that is you can do those things that are reasonably implied from reading the expressed authority. And then thirdly, you can do those things that have been declared essential to the needs of the corporation, which is the fancy term for cities, towns, and by extension counties. So when you look at the Dillon construct, every state in the Union acceded to that as a primary means by which we made judgment as to what a locality can do as a creature of the state. Remember, we're all creatures of the state. Charlottesville has no inherent right to exist. Richmond has no inherent right to exist. No sovereignty applies. The concept of sovereignty doesn't apply to a local government. Because we're creatures of the state, we have to look to Ma and Pa, who created us, which is the Virginia General Assembly. So Virginia, in adopting the Dillon construct, we are more of a strict constructionist Dillon state. Dillon is actually an applicable standard that applies in 36, 37 of the 50 states. Maryland is a home rule state. A lot of folks think, well, then, they can do whatever they want in Baltimore. No. In Baltimore, their charter reads exactly like the charter of Charlottesville. However, it'll say that Baltimore, in doing and addressing all of the assignments, duties, and responsibilities, are empowered to do all that is in the public health, welfare, of interests of citizens, save for the following list of prohibitions. Maryland General Assembly comes up with a list of prohibitions. So even in a home rule state, the Dillon construct is alive and well. Now, if we wanted to say we want more authority given to the local government, then that would take an act of the General Assembly to effectuate that. When Dick Howard was assisting from the Virginia Law School, still there, with the rewrite of the Constitution in 1970, that was advanced. Should we address the Dillon construct? Both VML and VACO said no. Interesting.
Mike, if I could just make
Yeah,
one point,
yeah.
because I think you need to look at, it's half full or half empty, since we're going to lunch, I'll use
Yeah.
a beverage theory, between home rule and Dillon rule, and it's what the General Assembly gives us powers, or in home rule, what it takes away.
Right.
And the bottom line with respect to legislation in Virginia relating to planning and to zoning is that it is quite broad.
Yeah. Dillon
And-
rule is
and-
of little consequence.
And so if you follow the scheme of comp plan, zoning to the comp plan, and then doing your subdivision site plan ordinances, then and exercise that discipline, you have quite a bit of authority. So if you get wrapped up too much in the issue of, gosh, we should have more authority, you really need to go back and look at how you're doing your land use planning. But remember, you also need to stay on your legislative delegations so that when you do something creative, and one of the disgruntled members of your community runs down the General Assembly, you're ready to tell them why it's good government.
That's a very good point. One last point before we thank the panel, and Mr. Weinberg, I appreciate greatly.
I take it to be the General Assembly could repeal the Dillon rule.
Well, they could add clarity to the Dillon rule, and I think Sharon has just made that somewhat clear in terms of they promulgate, they provide the enabling guidance in terms of the statutory direction.
Control themselves.
Yes, they can. And Sharon, I think, is 100% correct. If we look at, in fact, the Advisory Commission on Intergovernmental Relations, which no longer exists out of Washington, D.C., but about, whatever 1988 is to the present time, so 26 years, in looking at authorities given to local governments by states, Virginia was adjudged to have the 7th most powerful set of local governments in all the nation. So, Dillon rule is an important guiding construct, but is it one that precludes us doing things in the planning and zoning realm? Sharon's right. You read the statutes, and you see a lot of mays, and you see a lot of shells. So we have a broad field upon which to do the task for us. And as long as we do that within the confines of that playing field, and we're procedurally correct in doing so, you probably don't need the good counsel of these wise people up here. Meaning you don't have to hire them. But if you do need to hire them, I would suggest you talk to each of them. Great technical ability. Thank you all very much for giving me your time, and thank each of you for being patient and listening to this and hopefully gaining from it.